Hello, everyone. Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today, we have Mr. Nitin Kumar Bhatnagar with us. He is the founder and managing partner at NKB Legal. This is a full-service law firm located in New Delhi, India, and having associates network in all major parts of the country. Mr. Bhatnagar has got over 15 years of experience overall and more than 10 years in active litigation, out of which about 7 years in the independent litigation practice, where he founded the law firm NKB Legal in the year 2014, after working for a prominent IP law firm. Thank you so much for joining us, Mr. Bhatnagar, today. We are pleased to have you with us.
Thank you. Thank you, Mr. Vinay.
It's a pleasure to have you on the show, and I'm sure a lot of our viewers would be listening this show at this moment, and they would like to kind of get a lot of information about you and how you were able to have, start this law firm at your own NKB Legal. So let's start from there. If you can please brief us about your firm NKB Legal and your journey as a legal professional so far.
NKB Legal is my brainchild, which was conceived about 7 years ago. I was working for a very prominent law firm in the Delhi NCR region. And one of my very, very close friends who runs a big corporate investigation company, that's by the name of Greaves. He, in fact, encouraged me to go independent. And that's how NKB Legal started. And this friend of mine, who is Mr. Rajiv George, he supported the conception and the advent of NKB Legal, and that's how we started with some simple matters, and then from there gradually we grew into all kinds of matters, be it civil litigation, criminal litigation. And today we have a good team, and we are sitting at a prominent place, and we're doing a good job. We're satisfied with ourselves, and we strive to do better in times to come. So that's a small story.
Oh, okay. Well, that's definitely a small story, but you kind of helped us understand how it all started and what made you believe and what made you realize that you can go independent. And thanks to your friend who kind of helped you understanding that at the right time, probably. I'll move on to my next question now. This is again kind of a follow-up one on the previous question. So if you can tell us about the kind of cases your firm usually handles and what the expertise area of your firm.
See, usually, as I said, since we started in collaboration with the company of one of my friends who is into corporate litigation, corporate investigation. So the first kind of cases were the IP cases, but we honestly never restricted ourselves to IP work only. I had seen from my experience that if you need to do good in this field, you need to have multidimensional portfolios. So we kept on adding whatever came our way. In fact, I had a good knowledge of service law beforehand. So lots of service cases of very senior government officials, associations of senior government bureaucrats and all. Those kinds of cases started coming to us, which included their service disputes, which included fixation of seniority, intercadre disputes and all. So service law emerged as the second major portfolio of NKB Legal after the IP litigation. And then a lot of paralegal IP work also started dropping in, like registrations of trademarks and copyrights and several other similar things. And by the grace of God, we could manage a significant amount of international litigation also. That was by way of our connections and the network which we built over a period of years. We came in contact with some very good law firms located in Los Angeles, California, in London, and we started offering our services to them, whatever services they wanted from the Indian territorial domain. We started offering those services, and that's how we primarily divulged into three major segments. The first being the IP, litigation and IP work, which continues to be the bread and butter of the company. The second being the service litigation, which fetches us a lot of recognition, I would say, in the setup. And third being the international litigation, which is of course a very good source of revenue for us. So that's how we operate majorly into these three segments.
All right, thank you so much for answering that question. But I think my favorite portion was when you said that you did not really restrict yourself just to IP litigation and you took whatever came your way. As they say, journey is the best teacher how to walk. So you were kind of learning throughout the journey and adding those important aspects to the business. And this is what I would like to suggest all those young legal professionals as well. Keep learning, keep improving yourself, because legal fraternity or legal industry is not something where you have whatever you learned in the law school will be sufficient enough for you to sail through. You will have to keep learning and keep adding to your knowledge. I'll come back on to the next question now.
In fact, if I may just
Yeah,
add to
go
this,
ahead.
because
Absolutely.
you just mentioned about the young lawyers and the young legal professionals. So I really enjoy interacting with those interns, and I always have a word of advice for them, especially for the ones who are the first generation lawyers in their households, because normally it is very discouraging to see that a good number of first generation lawyers give up after some time. They either diversify into other segments or give up the profession altogether, which is due to the lack of opportunities. But then my suggestion and my advice to them as a senior, as an elder brother, would be never give up. I am a first generation lawyer. My father was into a government service, and I had no background of law, but then it was persistence and connections. I had to give a lot of years of my early life into a job. So you have to first fetch a job, be patient. Immediately, a job is not going to give you what you have expected. Don't give up. My only advice to the young first generation lawyers particularly is that just don't give up. The profession will do justice to you. You just be patient and give some time.
All right, so here's the word of advice for all those young professionals: stick around and do not give up. It will definitely flourish in some time, and you definitely have to, as I said before, you have to keep improving and keep learning from others, from your peers, from elderly or veteran legal professionals. I'll move on to the next question now, and if you can help us, understand, how do you look at IP litigation at this moment in 2021, 2022, and how it is going to change 5 years down the line?
See, whatever I have learned, first from the investigative point of view, I was an IP, you can say I was an IP investigator, and I still am. And then as a IP lawyer, this is something which is ever evolving. It is like the galaxy. It evolves with every passing day. You have new dimensions being added to it with each day, especially in lesser countries with lesser amount of awareness, like India. People are becoming more and more aware day by day. See, 10 years ago, if we think, it was only the very big corporates, companies, and big brands who were coming forward to protect their intellectual properties. But that's not the case anymore. Even a small-time businessman, somebody running a small eatery, or maybe somebody running a catering business, or even a small-time artisan would come and he knows that he has to get his trademark registered. He will come and say, you get my trademark registration done. He is equally aware. And I have personally felt this. So people are getting more and more aware. There is an ever rising trend. And with the slightly bigger ticket size of customers, there is another emerging trend which relates to the cross-border recognition of the intellectual property rights. These days, there is a surge in the number of WIPO, the WIPO trademark applications, because we are getting a good number of customers day by day who are coming to us and saying, I'm selling in New Zealand, I'm selling in Australia, I'm selling in Singapore, I'm selling in Germany. So you get my trademark registrations done in all these jurisdictions. Then they have to be advised on the WIPO process. And most of them don't know because, see, they are businessmen, they are not lawyers. We are the legal professionals. We are guiding them about the WIPO registrations and all. So all these things, they are emerging, and especially with the advent of this internet technology, and there is hardly any scope of or any concept of territorial jurisdiction in business, in international business fraternity now. You are dealing with multiple jurisdictions. So if you say, how do I see IP litigation or IP, the growth of IP awareness 5 years down the line, it is definitely going to be many-fold higher than what it is today. But I would say that 5 years is a very short span. It will continue to grow and grow, and it will one day it will constitute the most significant part of commercial litigation. So it's a wonderful concept. It is ever evolving. People are getting aware day by day, and the customer is very much educated, academically enlightened, and he knows exactly what is to be done. See, about 10 years ago, what used to happen? You had to advise the client, like look, Mr. X, you do this for your business. Today, that's not the scenario. He will come to you and say that I want to get this done for myself. And then so it is a very good concept, ever growing. And people who are into this, I have a number of people who say that it's nearing saturation. It is now in a position where it is exhausting itself. Now, that's not the case. You have to keep yourself updated. You have to keep yourself growing with this. You have to keep yourself updated with the case laws and with the rising trends of IP in all the sectors. So I see it at a very, very good pedestal 5 years down the line. And those who aspire to do IP litigation should keep themselves updated and continue learning in this segment. So that's what I have to say about this.
Amazing. So once again, I'd like to rephrase the words that you said for our viewers. It is not nearing saturation. It has not exhausted itself. It is still growing, and it
Yes.
is, as Mr. Bhatnagar said, it's ever evolving. It's like galaxy. It'll keep evolving and keep making opportunities for all of us. And one more point that I really liked about this particular answer by Mr. Bhatnagar is that even a small business knows, about this, and they really want to come up. They know what they really want to achieve. What's the goal? What's the endeavor statement? And they come up with that. So it is a lot of awareness that has definitely gone back into the system. And 5 years down the line, 10 years down the line, it's definitely going to evolve and improve and go many-folded higher than what we have it today. Thank you so much, and I really appreciate that answer. I'm sure it'll help a lot of legal professionals and a lot of businessmen to understand what is the importance of IP in every business in today's time. I'll move on to the question number 4 for the session today. And if you can help us know about your most memorable case and what are your key takeaways from there?
Well, if I have to recollect, there are 2 of them. And I'll briefly describe the first one. The first one becomes memorable because it was my first writ petition. Now, see what happens. Normally, there's a small child, a 3-year-old child. He goes onto the street and starts playing with a dog, a stray dog. A 12-year boy will not do that because he knows that the stray dog might bite him. But the boy is unaware, he'll just go and start playing with the street dog. So that was the case. I never knew how a writ petition, how relevant, how important is to get notices to the government of India issued in a writ petition. So when I came out, the writ petition got admitted. It was concerning certain group promotions. A group of government officers, teachers rather, was not getting promoted to the post of principal. That was before the division bench of Delhi High Court. I just presented my case, and it got admitted and notices issued. So I thought that it's a very normal process. I mean, that's okay. I came out and I told somebody there was a writ petition and the notice has been issued. I said, oh, wow, you got notice issued. Congratulations to you. I was thinking, what is there to congratulate? Later on, now years and years into service, and after seeing all dimensions of this phase, I can see why. I now realize why they were congratulating me. It was difficult, and I was a new boy. I did not know how relevant it is to get a writ admitted and notices issued to the government. So that was the first case, and why it became memorable is because a group of 250 teachers got promoted as principal, and all of them got their promotions. The government of Delhi went up to the Supreme Court in that, but over there also it was dismissed, and it was very satisfying at the nascent stage of your career, one's career. Such a big feat. It was definitely memorable, and my key takeaway from there was the way the judgment was written. The judgment was presided over by a bench by Honorable Justice Sanjeev Khanna, who is a sitting Supreme Court judge now. And so precisely, Honorable Mr. Justice Sanjeev Khanna and Honorable Justice Waziri was there on the bench. They have written the judgment so beautifully. It's a reported judgment. It's there on all the prominent websites. And the key takeaway in that case for me was how minutely you have to read government policies, government circulars and papers, and how beautifully litigation can flow. So that was one. The second case was a case where I was arguing an intellectual property infringement for a major global lubricants manufacturer. I would not like to take the name for confidentiality reasons, but it was a case of rampant counterfeiting across all parts of the country. So my client had wanted me to take a John Doe order. Now, John Doe order means I can have an order, and once I have that order, I'll take the local commissioner with me to any part of the country and enforce it on anybody who is infringing my client's products. So these kinds of orders are normally the judges hesitate in passing such orders because they can be misused also. But then the case was very well presented. We submitted proofs, pictures, videos of the infringements being done by various parties, and the bench was convinced. It was again a single judge bench of the Honorable Delhi High Court, and we got the John Doe order, and it's still in force. We are able to get it renewed every time we wish to enforce any party, any infringer. And the key takeaway from that case was if you have a good case, present it with proper facts, with proper proofs. Don't go by the the normal stereotype kinds of litigations and paper books. Make the paper books more attractive. Put a lot of pictures in them. Put a lot of diagrammatical and graphical analytical charts inside your pleadings. And definitely, if you have a strong case, even a John Doe order shall be given to you. And since then, we have taken it in a couple of cases. So those were, I would say, these are the two memorable cases.
I just love both those stories for different reasons, but definitely too much to learn. And thank you so much for inspiring us by sharing those two stories with us. Beautiful. I'll move on to the next one here. And here, if I can request you to let us know a bit more about your experiences with international litigation and what kind of matters you have handled.
See, international litigation, as I said, basically because of our connections, and I had known people in the industry for quite some time, we started getting some international cases. Those were from Dubai courts. Dubai is a three-tier justice system. We have the Dubai courts, then we have the Court of Appeal, and then we have the King's Court. Then we had some matters from the Superior Court of Los Angeles, California, and another case which we did in Gujarat High Court, that was a plea from an American company dealing into diamond trade. and it was an IP infringement suit against a company in Gujarat which was using the same technology for diamond cutting which the American company was using. So all these cases, they've more or less fallen into our bag because of our connections and our acquaintances internationally. But they've been very good teaching experiences. Every different court had a different style of working, and it was so I would say academically enlightening. It was so educative. In fact, like in the American court, it's about 7 years ago when things like appearing into the court through video conferencing and all were some things which never existed in the Indian system. So when we saw that in the appearance form itself, there were columns whether the attorney intends to appear in person or through video conferencing, and the letter used to put video to take video conferencing. So all these things were new to us, and we used to see how meticulously the courts function. You have the chart, you have a date of admission, you have a date of arguments, you have a date of counter arguments, then you have a date of final orders, you have a date of judgment. So the day you file your case, on the very same day, you know that it is on this date that my case is going to be decided by this honorable court. And then to learn those systems, to be a part of it, I got an opportunity to go there for an evidence, though I was, of course, not the attorney pleading the case because I cannot do it. But then I was doing all those pleadings and appearances in India. Like my counterparts who were handling the leg of the respective cases in their respective domains were pleading there, and I was pleading the parallel cases here in India. So we had one of the cases was in Karnataka High Court, the other one, the British court, one was in Gujarat High Court, and the one which was in Dubai court, a parallel leg was going on here in the Delhi courts. So it was really enriching to work on these cases. And these are all those cases where there was no scope of an arbitration. Because see, normally what happens when we talk of international disputes and international litigation, almost 95% of the people would normally say that this is all covered under arbitration. So for us, basically, when we say international litigation, by and large, we mean arbitration. But then these cases which I am mentioning, these are all those cases where there was no scope of arbitration because the parties were not known to each other. So that's how I look at it. And it's been very, very satisfying and very academically enlightening to work on these cases.
Well, the only thing that I can say about it is that, and this is again for a lot of young legal professionals, that even after having almost 14 years spent in the legal industry, Mr. Bhatnagar is still so much keen to learn. And that's what I could really figure out while he was answering this question. Once again, I would like to rephrase the same thing, that you need to keep learning and keep improving yourselves, because that's what the legal industry is all about and a legal profession is all about. I'll move on to the last question of our session today, Mr. Bhatnagar. Here, I'd like to understand generally when it comes to international disputes, the preferred mode of alternate dispute resolution, ADR. But is this the only mode? That's number one. Or do we have cases where ADR is just not possible? And if so, what are the challenges and efficacy of a formal litigation and how cumbersome it is?
See, as I said in the last question also, because we were talking of international litigation, see, ADR definitely, or arbitration, let me say arbitration, it's a very efficacious method of deciding legal disputes, especially when the problem is of territorial jurisdictions or cross-border jurisdictions. But then, see, arbitration is only possible when you have an arbitration clause or you have an arbitration understanding between the two parties. Now, we can't say that all the international disputes are covered under this. If I am doing business with somebody and I have business relations, I have got agreements, I have got contracts. In those contracts, definitely I'll put an ADR clause and we'll go for arbitration, we'll decide the seat of arbitration and all that. But what happens when I do not have any contract or any agreement and still I land up into an international dispute? Now, let us say, suppose there is a merchant and customer dispute. Somebody is selling marbles in America and he procures the marbles from somebody who is running a marble quarry in Karnataka. Now he sends him some shipment, the shipment gets damaged, the boat capsizes or the truck meets with an accident and the marble slabs break away. Now, in such case, if he doesn't have a formal agreement, they are just doing business on invoices or purchase orders. Definitely, if I am the aggrieved party and I'm sitting in America, the only way possible for me is to litigate. And I'll file a case in my jurisdiction, which is in America. Likewise, if there are several customer disputes where I don't have an alternate dispute resolution mechanism, I cannot go for arbitration. So I'll have to go for litigation. So in those cases, the international litigation is inevitable. Now, going by that, so this is wrong to say that ADR is the only mechanism in international disputes. We will deliberate upon that, but at this stage, due to paucity of time, we cannot just go on this. Now, many a times, see, you can't predict that there is going to be a dispute. So in those cases, definitely international litigation, it crops up in cases where there is a sudden discovery. I am an American company, and I suddenly discover, by way of my routine investigation, that there is somebody in some small corner of NCR, somebody in, let us say, Noida or Gurgaon, who is infringing my products. Now, I don't know that party. So the question of ADR does not arise. I'll have to start litigation proceedings. Either I'll do it in that jurisdiction or any of my representative office will have to do it in Delhi. So in many of the cases where I don't have a representative office, I'll have to do it from the respective country. Now, in that, suppose I am sitting in such a country which has got a reciprocating arrangement with the government of India. So about 14, 15 countries are there who have the reciprocating treaties. We call them reciprocating territories. Like they reciprocate our court orders and decrees and we reciprocate theirs. So getting a decree or a court order from a reciprocating territory is as good as getting a local or court order from your respective country. I have an order from the Honorable Delhi High Court. I can go and execute it in any part of India. I can go and execute it in Chennai, in Bangalore, anywhere. Same is the concept with a court order or decree which I am getting from a reciprocating territory. Now, the problem arises when there is a decree which is to be enforced and it is coming from a non-reciprocating territory. Now, in that case, the process is, I don't say it is not possible, but the process is a little lengthier. I have to file a civil suit which has to pass certain conditions. Those conditions are laid down in section 13 of the CPC. There are general conditions. The decree should not be obtained by fraud. The decree should not be an ex parte decree. And there are several other parameters which the order has to meet. So based on that decree, I have to file a fresh civil suit. But even in that fresh civil suit, this decree or court order from the non-reciprocating territory shall also hold evidentiary value. So it's not again going to take the same large amount of time and litigation going on for years and years together. That's not going to happen. But then there's a process of doing it. So basically, from reciprocating as well as non-reciprocating regions, we have efficacious mechanisms in the Indian legal system to enforce the court orders, the foreign court orders and decrees, and execute them. So international litigation over and above ADR. See, ADR, no doubt, it's the most efficacious mechanism. But apart from ADR also, there are several other modes. The conventional litigation mode, which is equally effective, and it's very much into the system.
All right. Thank you so much for answering that question to us and helping us understand different methods that can be used in certain situations. I'm sure a lot was there to learn and to as you know that we can take as a takeaway from this quick session. I'd like to thank you for sharing such great insights with us, and we look forward to having a chat with you again in the future on some other topics relating to the Indian legal fraternity and international legal industry. And with that, we come to the end of this session. For our viewers, if you like this chat, please like and share this video, and also subscribe to ClickAway Creators YouTube channel to appreciate what we do and have more coming from the industry leaders. Thank you so much for joining us today. This is Vinay for LexTalk World.